welcome back to the afternoon session of the September docket of the Court of Criminal Appeals for Jackson. Would you call the next case, please? Unless we don't have any preliminary matters this afternoon, do we? Okay.
State of Tennessee versus Jarvis T. Emerson.
Good afternoon, Your Honors. May it please the Court, I'm Mitch Raines with the Public Defender's Office today on behalf of Mr. Jarvis Emerson. At this point, I'd like to reserve 4 minutes for rebuttal. Thank you. I raised a number of issues in my brief. Today, I'm going to be ambitious and try and talk about 3 of them. Of course, if you have any questions about any other issues, I'm happy to address those. But hopefully I'll be able to cover the especially aggravated burglary issue, the simple assault, and then consecutive sentences under Wilkerson. As to especially aggravated burglary, in the reply brief, there's a section where I have argued under Apprendi that when a jury is tasked with evaluating attempted first-degree murder with serious bodily injury, that the serious bodily injury prong needs to be submitted to the jury. I did that because I think that there's a way you could read the state's brief where they argue that that isn't a requirement by saying that it's on an element of the offense. So just to cover the bases, that's why I raised Apprendi. But in this case, there was a jury instruction that defined serious bodily injury for attempted first-degree murder, and the jury did find that there was serious bodily injury to support the enhancement for attempted first-degree murder. So I don't think this court has to specifically rule on that or address that. I just, out of an abundance of caution,
So is that made a special finding?
Yes, it's a special finding, okay. And the TPI reflects that if there is attempted first with serious bodily injury, the serious bodily injury also goes to the jury, and that did happen here again.
But in this case, though, and I think you pointed it out in your reply brief, when the trial judge charged the jury on attempted first with serious bodily injury, he did not include that as part of the what the jury had to find. Am I right about that?
So there's a difference in the record between what was actually given to the jury and what was put in the technical record as far as the printout from the jury instructions. What I was trying to convey, and maybe I didn't do it well, was that when the trial court gave the oral instructions to the jury, it did define serious bodily injury for attempted first-degree murder, and that was also reflected in the judgment sheet that the jury was given. But the written copy of instructions, which I don't have anything in the record to say that those were or weren't the same copy that was sent back, it didn't happen there. It was just the standard attempted first-degree. But the instructions that were actually read out to the jury were proper.
What the transcript shows is what you're saying.
Yes, Your Honor. The transcript shows the right jury instruction was given. But I do think that Apprendi is still helpful, or at least it's a progeny of cases in helping this court evaluate whether or not the serious bodily injury and same acts apply for both attempted first-degree murder with SBI and then also especially aggravated burglary. Under Apprendi and some of the cases that have evaluated that, they talk about a functional equivalent. So while I recognize Tennessee case law says that a serious bodily injury is not an element of the offense, I do make an argument that it works as a functional equivalent. But again, I don't think this court has to reach that in order to find that the especially aggravated burglary has to be reduced down to aggravated burglary. And the reason why that reduction has to take place is because the especially aggravated burglary statute specifically says that if you're relying on the same set of acts to prosecute especially aggravated burglary and another offense, then you have to choose. You can either do especially aggravated burglary or you can do the other offense, but you can't prosecute for both of them. I also go through in my reply brief the distinction between prosecute and conviction. The language of the statute is that you cannot prosecute. So because of that, because it's one set of actions where Mr. Emerson went into Mr. Buchanan's house and shot him, those are the same acts that support especially aggravated burglary as attempted first-degree murder. And because of that, especially aggravated burglary has to yield, given the mandate in the statute. There's also a number of other cases that have found that dealing with similar issues. In my brief, I also noted that the Johnson case was relied on in this court's decision in Tolbert. In the Johnson case, it was a felony murder and especially aggravated burglary, where the aggravated burglary had to fall down. So if there are no questions about that, I'll move on to the consecutive sentencing issue.
Well, let me ask you a question on that. If we
Yes,
agree
sure.
with your analysis that he cannot be convicted of both, and we do reduce the especially aggravated burglary to burglary,
Just aggravated.
to aggravated burglary, yes, excuse me, would we, as far as sentencing goes, that's going to affect the sentencing because these are, at least the way they are now, they're consecutive.
Yes, Your Honor.
Would we have to send it back to the trial court for resentencing?
I think that the best practice would probably be to do that, and I can address that also as
Okay.
far as consecutive. For purposes of consecutive sentences under Wilkerson, the state has already conceded that Wilkerson was not properly applied. We would ask this court to accept that concession. If you agree that especially aggravated burglary has to be amended down and also consecutive sentences need to be readdressed, this court has said many times that its preference is to remand back for a new sentencing hearing with instructions to kind of guide where the errors were. I believe as recently as yesterday in State versus Frazier, this court, Your Honor, Greenholtz authored that one, remanded a sentencing issue back because the record didn't support appellate review. I think it would be the same logic here.
I mean, Frazier was a little different than this case.
It was.
I mean, in Frazier, you had a real question about what the underlying crime was.
It was, but as I pointed out in both Ragland 1 and 2, which are both dealing with Wilkerson findings, in Ragland 1, this court also noted that given the lack of findings and the specific, what am I trying to say? How the considerations are embedded in the local community when it comes to Wilkerson findings, that it's best to remand back for the trial court to reconsider or to put additional findings on the record to support its conclusion. I also argue under Ragland 2 that we have the same trial court here, we have the same situation. The charges might be different, but it's the same factual situation. So for judicial economy, I think it would be more appropriate in this case than perhaps otherwise for this court to go ahead and conduct a de novo review. And then we would also argue that there's insufficient information in the record for this court to say that a 55-year sentence is more warranted than a 35-year sentence, given the severity of the offense and least restrictive measures that have to be applied, which also kind of dovetail into the dangerous offender findings.
The especially aggravated robbery, what did the trial judge, what was the sentence?
On especially aggravated burglary, that
Burglary,
was, I believe, a 20-year sentence.
So that's the max on a B, range 2?
Yes, Your Honor. I
Okay.
believe so.
Well,
I
8 to
believe
12,
so.
12 to 20, yeah, 8
Yeah.
to 12, 12 to 20. So
I
the
think-
max,
I believe
so
you're
the
right.
judge did the max, so, well, anyway. If we're looking at a C, the max on a C, 3, 6 to 10 would be 10, right? Range 2?
Yes, Your Honor.
Okay.
I think
That-
that
Consecutive
math
sentence, a whole
maths.
other issue. I'm just thinking about if the judge does the max on a B, then,
Yes, Your Honor, and there are two offenses that I recognize, or that we recognize have to run consecutive, and those deal with the firearm convictions. I don't plan on talking about that today, but if you don't agree with my argument in that, then those would by law have to run consecutive to that as well.
I mean, Pollard itself didn't Pollard itself remand for new findings on Wilkerson itself, noting that Wilkerson is unlike a lot of the other consecutive sentencing categories. It's highly fact-intensive. You have to make those judgments. I mean,
Yes, Your Honor.
hey, the Supreme Court suggested that'd be the appropriate path. Can I go back to the especially aggravated burglary?
Yes.
Again, as I understand the argument is that, so attempt 1 with serious bodily injury and especially aggravated burglary with serious bodily injury cannot both be prosecuted because the statute, especially aggravated burglary statute, says that you can't prosecute both. You can prosecute one or the other.
That's correct.
So, so help me with, and I know you've addressed this in your brief, but help me with prosecute. So in attempt one, serious bodily injury is not an element of the offense. It's purely a sentencing factor. And so the jury's not asked to make any kind of finding with respect to guilt or innocence on attempt one using serious bodily injury. Black's Law Dictionary defines prosecute as the guilt or innocence determination and seems to exclude from that sentencing. And I wonder, too, if that actually makes sense, because in a sentencing situation, and let me see what the response to this may be. Unlike a trial where the state has the burden of production of proof at trial to secure a conviction beyond a reasonable doubt, the state has no burden at all at sentencing. It has no burden to come forth with any evidence. It has no burden of persuasion with respect to sentencing. It can offer proof if it wants to. It can make arguments if it wants to, but it has no burden. And so if the state has no burden at sentencing, and the common ordinary meaning of the word to prosecute may not include sentencing, but talks about the guilt innocence determination, how are two offenses being prosecuted here for serious bodily injury?
Yes, Your Honor. So I
That's
think
a
that
long wind-up, but that's, I think, what I want to focus in on, what is actual prosecution, particularly in the context of attempt one.
So I made a distinction in my brief between prosecute and conviction, because that is something that this court has somewhat conflated, looking at Holland, where it found that a remand was necessary, or not a remand, but a reduction was necessary for especially aggravated burglary, because the defendant in Holland couldn't be prosecuted and convicted for the same offense. I think that the real focus, though, needs to be on when the statute says acts. And both Talbert and Holland and the other line of cases that are noted in my brief also focus on the word acts. And the statute says that acts which constitute an offense under this section and can also be prosecuted under another section, you can't have both. And here we have the same acts.
Yeah, but we don't have prosecution, and I understand the same acts. I understand the same serious bodily injury.
There wouldn't be a prosecution for attempted first-degree murder if not for the breaking into Mr. Buchanan's home and shooting him. And the same can be said, there would not be a prosecution for especially aggravated burglary or even aggravated burglary if not for the breaking into his home and then the shooting, which would be the felony
But
within.
the acts in a prosecution are relevant only to the extent that they establish elements. And so the jury is tasked with coming to a unanimous conclusion on elements, not necessarily facts to support elements, but elements. And so if the focus really should be on acts being elements, I mean, that doesn't seem to follow.
I don't know how this court, just to be honest with you, could find that the elements of either offense are not both supported by the same act, if that makes sense. We have one action. We have the breaking into Mr. Buchanan's home, and then we have the attempted felony or the felony taking place. And that singular action of breaking and entering and then shooting Mr. Buchanan meets elements under both attempted murder as well as aggravated burglary. So I think even pulling back from serious bodily injury, if this were only charged as attempted murder without the serious bodily injury enhancement, it would still be the same act that the state was prosecuting under both statutory provisions, and that would still require, especially aggravated burglary, be amended down to aggravated burglary.
Okay, thank you.
In just a couple of minutes I have left, I'll move on to simple assault, unless there are any other questions. And for the simple assault offenses, there were 3 of them. They were originally indicted as aggravated assaults. The jury returned lesser included offenses of simple. And the state argues that a common sense inference would allow the jury to convict Mr. Emerson of all 3 of those offenses by saying that they could have feared for their personal safety.
Did any of the 3 testify?
No, they did not testify.
I know 2 of them were children, I believe.
Yes, Your Honor.
The adult didn't testify either.
No, one of the children was 6, the other was 3. The adult, Mr. Wilkes, he did not testify either. He does appear on a body cam where he says an expletive. That's about the extent of his interaction there, and that's while Mr. Buchanan is being rendered aid by emergency services. So nobody testified, and most importantly, nobody testified about any of the physical or emotional state of any of these individuals. I understand that you can have a conviction for this without the victim testifying. I'm not contesting that at all. But in every case that I've looked at that has relied on that, there has been other testimony by someone else who says, to use Whited as the state's example, who said that there was a 17-month-old baby. Testimony that the child was crying and grabbing at his mother during a heated altercation, that the defendant tried to pull the child away to get at the mother, and that the child started crying after the first gunshot. Here we have absolutely no testimony about how those 3 individuals acted or responded, or even if they were aware of what was taking place. So it would have been easy for the state to obtain a conviction in this if someone had said, the kids were crying, Mr. Wilkes woke up and said it's a gunshot, something along those lines, but there just wasn't anything here. So I think that this court needs to vacate those convictions as well. And with that, I'll save the remainder of my time for rebuttal. Thank you.
Can I follow up on that just very quickly? I mean,
Yes, sir.
the law does allow circumstantial evidence to suffice for reasonable fear. If, for example, a reasonable person in the same position as the victim would have felt fear at that point. Can you address that?
Because there is such a lack of evidence about anything other than the circumstances of the shooting. So there's no indication that any of the 3 individuals woke up when they heard gunshots, that they ever heard gunshots, that they ever knew what was taking place in the home. Without that, it's all pure speculation. Okay. And as this court has said time and time again, you cannot speculate the accused into the penitentiary.
Sure. Very good.
Thank you.
Thank you.
Good afternoon, Your Honors, and may it please the court, Ronald Coleman on behalf of the state. This court should affirm the judgments because the evidence was sufficient to establish the defendant's guilt and because the consecutive sentencing is appropriate. So first, I want to make sure that we're sort of all on the same page, and to the extent that our brief was confusing, I sincerely apologize. I think we are all in agreement that the serious bodily injury sentencing enhancement for attempted first-degree premeditated murder has to be submitted to the jury under Apprendi because it is something that enhances the mandatory minimum sentence. So that has to be presented to a jury and has to be found beyond reasonable doubt. That's what Apprendi says. So we're all in
beyond the statutory maximum.
Yes.
Okay. Sure. No, that's fine.
Yes, but Apprendi mandates that this has to go to the jury.
For that enhancement, though, it increases the release eligibility date, correct?
Correct. It is simply a sentencing enhancement. It goes from, I believe, 30% to 85%.
Okay.
Similar to a
So
drug-free zone enhancement, other sentencing enhancements.
Okay.
So when we're looking at this question of especially aggravated burglary and being prosecuted with another act, I think that's important. And Tolbert, the statute says prosecute. Tolbert has interpreted that as a conviction involving joint elements of serious bodily injury, and we don't have that here. The defendant seems to focus on the word prosecute, but I think, Judge Greenholtz, you've made several good points about how the state prosecuted this defendant for attempted first-degree premeditated murder, full stop, which has no elements of serious bodily injury, and then also prosecuted him for especially aggravated burglary, which does include it.
Well, see, I tried to get your friend into that box, and he was unwilling to go. So I tried to focus him in on prosecute, and he said, that's not what I'm focused on. I'm focused on acts. And the statute requires that acts cannot be prosecuted. And what I heard him say, but this is what I want to ask you about, is that the exact same acts that formed especially aggravated burglary also formed attempt 1. and that there are no facts in between that distinguish them. So while we're proving different elements with each, the acts themselves are exactly the same. So
And I would
help me with
disagree.
that. Well, I mean,
So,
certainly, but
so
why?
because under the facts of this case, the defendant could have completed attempted first-degree murder, full stop, by breaking into this victim's house, going to his bedroom, and firing a shot and missing him. We know that the defendant fired over a dozen shots. We know the victim only suffered 11 gunshot wounds, so he had to have missed one. By firing and missing, he has completed attempted first-degree premeditated murder, but by failing to inflict serious bodily injury during that act of firing that singular gun,
For that one bullet.
he failed to inflict it. And so that's why we have to look at the elements, I think, because once we get to these facts, it still supports it, but it involves a little bit more speculation. But still, he could have fired, he did fire the gun, miss, commit attempted first-degree premeditated murder, and then by continuing to fire and inflicting serious bodily injury, he then consummated especially aggravated burglary. That's why when we're looking at these two offenses, the easiest way to do it is under Tolbert is to look at, do they both have elements of serious bodily injury? And here it doesn't. This is purely a sentencing enhancement. If the jury did not find that he somehow found that he did not inflict serious bodily injury during the attempted murder, it still would have been a conviction, and they still would have prosecuted him for attempted first-degree murder. The serious bodily injury at that point only goes to what his sentence should be. So whether it be acts, whether it be prosecute, whether it be convictions, these are two distinct offenses that allow for this court to maintain the especially aggravated burglary conviction. Before moving on, I did want to go to your question, Judge Easter. If you disagree with the state and you agree with the defendant that this gets reduced, I think you have to send it back to give the trial court an opportunity to impose the effective sentence that it wants. When you look at this trial court's findings, they're pretty lengthy. They go over, I think, 7 or 8 pages. And at the end, the trial court makes abundantly clear and, in fact, imposes some consecutive and some concurrent sentencing, specifically with the intent of, I want this to be a 55-year sentence. And so if we're reducing, if this court chooses to reduce one offense, it needs to remand to allow the court to consider that when, again, determining what the proper sentence is. But state submits that that doesn't have to be a concern because especially aggravated burglary is appropriate here.
Can we, it sounds like based upon your brief and based upon statements made by counsel for the appellant, that the state is agreeing there's insufficient Wilkerson findings here for consecutive sentencing.
I'd agree that the trial court did not make the requisite Wilkerson findings correct.
Is the appropriate remedy there to send it back to the trial court?
So I think there are two appropriate remedies. This court can certainly remand it for the trial court to do, to make additional findings. That is within its prerogative. We would submit that for the sake of judicial economy, especially if you agree with us that the sentence for especially aggravated burglary doesn't need to be reduced. It makes sense for this court to just consider consecutive sentencing on its own. And here we submit that the record is more than replete for this court to make that determination. While the trial court didn't make the Wilkerson findings, the record overwhelmingly establishes that. First, the defendant showed a pattern of harassing and threatening behavior before he escalated it to attempted murder. He had a risk score of high or moderate in several areas on his validated risk assessment. Even still, he denied needing to change his lifestyle or that he had ever engaged in criminal behavior. Consecutive sentencing under the first Wilkerson factor is warranted to protect the public from this. And then it is also appropriate the 55-year total aggregate sentence is reasonably related to the severity of the crime because this defendant broke into an individual's house in the early morning hours, jeopardized not just the victim of the attempted murder, but 4 other individuals who were present, and didn't just fire a gunshot at the victim. Instead, fired over a dozen, hitting him 11 times. Essentially, the defendant is lucky that this victim was so tough because this could very easily have been a completed murder with 11 gunshot wounds. This was not just an attempted first-degree murder, not just an especially aggravated burglary and these other offenses. These facts are particularly egregious. And so this court can easily find that the aggregate sentence reasonably relates to the severity of the offense. So by making those findings, this court should uphold the partially consecutive sentencing that was imposed by the trial court. If this court doesn't have any questions on sentencing, I'll turn to the final issue that my friend on the other side has raised today, which is the assault convictions. And to your point, Judge Easter, none of the 3 victims in those testified. I will note, I think there was commentary today that no one even said that it woke them up or that they heard anything, and that's the record belies that. The adult individual who was in the living room was captured on body cam, and he says an expletive, and then he tells police, I heard a lot of gunshots and it woke me up. And we cite to that in our brief, but he tells the police officer, this woke me up. So we know that it was certainly within hearing range, and there's also testimony at trial that this was 10 feet away.
But there was a wall, right?
There was an interior wall. Yes.
I mean, it's a real wall.
It is a real wall, but
Okay, so the other part of the question, though, is was there any other charge in which those 3 were victims?
they were victims charged with aggravated assault. That by firing this weapon at the attempted murder victim, the defendant placed these 3 individuals who were 10 feet away with reasonable fear of imminent bodily harm.
But not reckless endangerment or anything like that?
I don't believe it was reckless endangerment, no. It certainly could have been, but I think the state... But ultimately, any rational juror could easily find that 3 individuals sitting 10 feet away from where a person fires over a dozen gunshots could have not only been woken up by them, which we have proof of, but also could have been placed in fear of imminent harm. Ultimately, that was a question for the jury. While we don't have these victims to testify, or while they didn't testify, that is not fatal. And this was a question for the jury, which they very clearly considered and reduced the offense to simple assault instead of aggravated assault. So they were considering this, and they reflected on it.
Would the victim have to be aware of the gunshots for aggravated assault to apply?
I think for either aggravated assault or assault, under the theory that it put them in imminent fear of bodily harm, I think they'd have to be aware that something was going on.
Okay.
I think
where is that then with respect to at least 2 of the victims?
Hearing gunshots.
Okay.
I think any rational juror could say that when there's a gun being fired 10 feet away, just practical experience, you're going to hear that.
Okay. So absent even a victim testifying that the victim was aware of the gunshots, the jury can make the inference that they must have been aware?
Yes, the jury can infer that. So ultimately, on the 3 issues presented today, we submit that because serious bodily injury was not an element used to prosecute or convict the defendant of attempted first-degree murder, the especially aggravated burglary conviction can stand, that this court on a de novo review, should it choose to do so for judicial economy, can find that partial consecutive sentencing was appropriate, and that a jury could reasonably infer that the 3 victims in the living room were placed in fear of bodily harm. If there are no further questions, I'm happy to defer to the other issues on my brief, and we would respectfully ask that you affirm the judgments. Thank you.
Thank you, Your Honors. Just briefly, I would first just note that if this court were to accept the state's concession that under Apprendi, the serious bodily injury enhancement for attempted first-degree murder has to be submitted to the jury, and I would ask this court to agree with that, that leads or lends all the more credibility to the argument that under Apprendi, that would count as a functional equivalent to an element of the offense.
Apprendi is a sentencing case. It's a sentencing case.
It's a sentencing case.
It's not a guilt or innocence determination issue. It's a sentencing enhancement.
In my reply brief, and I have to look back at it, there's a string of cases that have come after Apprendi that have applied that to what they call the functional equivalent.
Sure.
To encompass elements that are outside of the I guess listed elements of the offense. And so that would be the same rationale would apply here. right? If the sentencing enhancement is something that has to be submitted to the jury, then under Apprendi and its progeny, I think that that would also apply to say that it is the functional equivalent of an element of an offense. Separate and distinct from that, though, is also the statutory language. It is acts, the same acts, similar acts. We see that time and time again in case law. And the state put forward that Mr. Emerson could have completed the attempted murder by breaking in and just firing one shot. First of all, it's the acts that we have before us in this case, not what could have been. No ifs, ands, or buts, it's what actually happened. Mr. Buchanan's home was broken into. He was shot multiple times, more than once. Even operating under he could have only been shot once, that still could have resulted in serious bodily injury and then still been the same act for both attempted first-degree murder with SBI and especially aggravated burglary.
So how do you respond to your friend's argument, though, that you had a dozen shots fired, one bullet missed, and so the jury could have concluded that attempt one, just on the elements of attempt one, could have existed simply from that, and that would be a completely separate offense from the especially aggravated robbery? How do you answer that?
If that's the case, if it were just the one, then again, I think we're back into the realm of speculation, because under the actual facts of this case, it wasn't just one shot. But had it been one and it been a miss, then applying that same rationale to especially aggravated burglary, it wouldn't have been especially aggravated, because a shot that misses doesn't result in serious bodily injury. There has to be a connection to result in a serious bodily injury. And that is what happened
We're giving a lot of weight, appropriately so perhaps, but we're giving a lot of weight to the supplemental factual finding that the jury made. I think that what the state was saying is that it still could be possible, though, that the jury could find attempt one with the missed bullet. And so even though they're making the supplemental finding that there is serious bodily injury also, but if they could make it with the missed bullet, then that takes you out of your you can't prosecute for both sets of acts.
I think to cherry pick facts like that just to support a conviction when that's not what the facts bore out at trial would set a dangerous precedent, perhaps, in cases with fact patterns similar to this. And unfortunately, we do see where people are shot at and then struck multiple times as well. So again, I would say based on the facts that we have before us, I think it's obvious that it was the same offense or the same act that underlines both attempted first-degree murder with serious bodily injury and especially aggravated burglary. And then as to the state's last point, I am unable to recall whether or not Mr. Wilkes said that he woke up to gunshots. If that is truly the case, I don't doubt the state's characterization of that. I still don't think that imputes any knowledge or information about what the children actually knew or experienced. And so without even basic testimony that the kids also woke up or that the kids were crying, I again just don't think that there's enough to support those two convictions. So again, we would ask there was a myriad of relief sought, and I would ask for just all that to apply.
Before you sit down, I wanted to ask you about, as I understand the issues that you're raising on appeal, is sufficiency of evidence and then the sentencing issues. Those are the only two issues you're raising.
Those are the two. Those are the two broad categories, and then there are, I think, two sufficiency issues underneath that, and then 4 sentencing, or maybe it may be 4 sufficiency and 2 sentencing.
But the especially aggravated burglary, serious bodily injury, attempted first-degree murder, serious bodily injury come under your sufficiency argument?
Yes, Your Honor, because the statute.
Was it framed that way at the motion for new trial?
I don't recall, to be quite honest with you. I honestly do not recall what issues were raised in the motion for new trial. I did not.
Insufficient evidence, just
Yes, Your Honor.
the blanket insufficient evidence.
Yes, Your Honor. And I think that the especially aggravated burglary, dropped down to aggravated burglary, falls under sufficiency of the evidence because of the statutory provision that prohibits prosecution for 2 separate offenses under the same act. I think that framework encompasses that. And this court in Holland, at least I know, addressed that issue sua sponte, without any of the parties raising it, and found that because it was a statutory mandate, that it had to be reduced. Thank you, Your Honors.
Okay, Madam Clerk, would you call the next case then, please?
State of Tennessee versus Joshua Damone Pewitt.